For 5 minutes.
Thank you, Mr. Chairman. Attorney General Sessions, thanks for being here. General Sessions, who do you work for? Do you work for the American people or do you work for the President of the United States?
Well, I'm a member of the executive branch and I work for the American people.
And it's with that in mind, your work on behalf of the American people, that I want to ask you some questions about facts and public media reports. On February 14th, the President asked the FBI director about the Flynn investigation, and I quote, he said, "I hope you can see your way clear to letting this go, to letting Flynn go. He's a good guy. I hope you can let this go." Close quote. Then on May 9th, the President fired Comey. On May 11th, he went on television and announced that he fired Comey because of, and I quote again, "the Russia thing with Trump and Russia," close quote. General Sessions, do you think it would be reasonable for the members of this committee to conclude that the President, by first interfering in one investigation and then interfering in an investigation into himself, committed obstruction of justice?
I don't believe that's a fair conclusion, and but it's a matter that I guess would be in the breast of the special counsel. The obstruction of justice being any, among other definitions, the most popular one in statute, any communication that endeavors to influence, obstruct, or impede the due administration of justice. That's exactly what the President did in both of those cases. And in spite of, moving on to the special counsel that you brought up, in spite of efforts, bipartisan efforts to protect the special counsel, Mr. Mueller, Republican leadership and this committee have refused to take action to ensure that he's protected. Do you believe that the President has the legal authority to fire Special Counsel Mueller? I'm not able to express an opinion on that at this
point. Can he fire members of the Special Counsel's team?
I'm not able to answer that.
General Sessions, do you believe that the President should have the authority to be able to block investigations into his own campaign?
Investigations have to be conducted by the appropriate law enforcement officers without fear and favor, without politics or bias.
Right, and without fear of being dismissed by the President in order to block that investigation, because again, that would certainly appear to represent obstruction of justice. And when you fail to acknowledge that, it is essentially a green light to the President to go ahead and do that. And now I wanted to talk about the special counsel's investigation. Thus far, there have been some indictments. There's a guilty plea. Can you tell me, in your opinion, does the President have the power to pardon George Papadopoulos?
It would be premature for me to comment on that, I believe.
Because?
The President has power to pardon. There's no doubt about that.
Right. Does he have the power to pardon Paul Manafort and Rick Gates ahead of a trial and a conviction?
I'm not able to comment on that. I haven't researched that question. I think it's settled, maybe settled law, but I'm not.
What do you think the settled law is?
I don't know.
And does he have the power to pardon Michael Flynn, any other member of the Trump campaign? Let me ask you this. Does the President have the power to pardon his own family members? Could the President today pardon Donald Trump Jr. for, among other things, being in contact with WikiLeaks regarding these emails? Can he make those pardons today before there's anything further that comes from the special counsel's investigation?
I would not be able to answer that at this moment with any authority.
General Sessions, you started by telling us that you're the American people's lawyer. Now, you're not recused from giving us answers on these. You're not comfortable giving us answers on these. But here's the problem that we have. You said when you started your testimony today that there is nothing more important than advancing the rule of law. And when you answer the way you have, it suggests that the rule of law is crumbling at our feet. You took an oath to uphold the Constitution. We took an oath to uphold the Constitution. And while members of this committee in the majority may choose to abdicate their responsibility with regard to these very important matters, you cannot. And the interference, what you've told us today in just this exchange, what we should all be concerned about is another Saturday Night Massacre. If you can't tell us that the President shouldn't fire or can fire the special counsel and everyone who works for him. We should be worried if you're telling us that the president may be able to pardon in advance all of those who are being investigated. We should be worried about the pursuit of the rule of law. General Sessions, again, we may in this committee.
The time of the gentleman has expired. The Attorney General can respond if he chooses to do so.
Just briefly, one of the things, if you respect the rule of law, is the Attorney General should not be giving legal opinions from the seat of his breeches. So you need to be careful about that, and that's what I'm saying to you today.
I do appreciate that, General Sessions.
Expired.
These are not new issues that I would think require you to
Texas,
give these
Mr.
opinions
Poe.
from the rule of your
Thank you,
breeches.
Mr. Chairman. Mr. Sessions, I'm over here on this side. If pursuant to a warrant, there is a wiretap, conversation is seized under the Foreign Intelligence Surveillance Act, and one person is a foreign agent, the other person is an American citizen, is the release of the information regarding who the American citizen is and or the conversation of the American citizen a violation of federal law?
I believe it is.
And if somebody releases that information,
Maybe factual distinctions.
I know,
but I
I'm just
think
hypothetical. Somebody releases the information of the name of that person and or the information contained by that person, that is a federal offense.
unacceptable, and it could be a federal offense.
So has anybody been prosecuted under your regime for doing that, whether it's been in the White House or some other government agency where we hear about leaks of classified information? Are you prosecuting anybody for that?
For release of FISA-obtained information.
Release of the information of who the American is and or the conversation by the American. That's classified information. Is your department investigating anybody for that?
I cannot confirm or deny the existence
Or are
of
you
an
prosecuting
investigation.
anybody for that?
Nobody is under indictment, although we've got at least 4 indictments this year of leaks of classified information,
Right.
and
I wanna
we
talk
will
about
continue to press those cases.
All right, good. We want to talk about the Foreign Intelligence Surveillance Act. Secret courts issuing secret warrants to get information on terrorists overseas. That's generally the purpose of the FISA law and FISA courts. Would you agree with that?
Well, that's not a perfect summary, but it's
not
got
short.
substance to it.
It's too short. We know we can't trust the NSA. James Clacker testified before this committee in 2013 that the NSA was not spying on Americans. Then all of a sudden, this guy named Snowden showed up, and we found out, whether I don't like Snowden at all, he ought to be prosecuted, I think. But anyway, we learned that the American public was being spied on by the NSA. Part of the Foreign Intelligence Surveillance Act gives the NSA authority to seize information like emails, text messages, communications by these bad guys, foreign agents or terrorists overseas, to collect their information to make sure that America is safe. During that process, as you know, incidental, they call it incidental information, information on Americans, who they are, and what those conversations may be, is also seized. The NSA says that's incidental information. Now, it's my understanding the Justice Department is opposed to the USA Liberty Act, which would require that before government goes into that information on Americans, when they're not the target's these terrorists, goes into that information on Americans, that there has to be a warrant signed by a real judge that states probable cause before that information can be seized. Now, my understanding is the Justice Department, under your leadership, is opposed to that warrant requirement. Is that correct?
That is absolutely correct.
So, you're a former judge.
Would-be judge.
Pardon?
A would-be judge.
Yeah, I want to be judge, yeah. I'm a former judge, too. You don't think probable cause and a warrant requirement is required to go into that information that is, first of all, the seizure is done by government without a warrant. So it's seized already. And before it can be then searched, you also don't require or believe that a warrant should be required by any court to go into that information.
Well,
I'm just asking the same question.
the courts have so held.
I'm not asking that question.
Well, I agree with the courts. Not you, Congressman, on that. You get lawfully obtained records, documents.
Reclaiming my time.
Right.
You agree with the courts on that, not me. But let me tell you something. It is the responsibility of Congress to set the privacy standard for Americans.
That is
my
correct.
personal opinion, and I think the Constitution supports it, that before government can go in and see something and then search it on an American citizen that's incidental to the search on the target, government should get a warrant for that conduct. That's spying on Americans. And we know that we can't trust the NSA to keep from doing that. Is that data ever destroyed on Americans? Or is it kept forever?
I believe it has definitely has a limited time span, and I think it's 5 years.
So Americans shouldn't be concerned that information is being collected on them and searched, and you don't have any say-so about a warrant.
Has expired. The chair recognizes the gentleman from Illinois, Mr. Gutierrez, for 5 minutes.
Mr. Chairman, before I begin, I think I have a solution that could allow the committee to move on to other important national matters like gun control and immigration. Your side clearly wants an investigation of Hillary Clinton, and our side has been begging for months to hold hearings and start an investigation of the Trump administration and campaign's improper ties to Mr. Putin and the Russian government. My solution would save the American taxpayers a lot of grief and a lot of money by eliminating the need for the investigations. I propose we simply go to the president and the former Secretary of State and ask them both to resign. I'll go to Hillary Clinton, you can go to Donald Trump, and we'll say them both to resign. Then we can move on as a nation from an election that just never seems to end. Now, I did Google organizations that Hillary Clinton leads, and it came out 0. So I'm not quite sure what you're going to get her to resign from, because she doesn't appear to be in charge of anything. Last time I checked, she got 3 million more votes than Donald Trump, but she lost the election. So I don't know, why don't we move on and really look at the nation? So, Attorney General, I'd like to ask you, you said earlier today it was a brilliant campaign, referring to the Donald Trump campaign. Is that true? You feel that?
It was a remarkable thing that overcame a lot of obstacles.
Brilliant campaign.
When
now,
people couldn't have...
In campaigns, candidates make promises during campaigns. You think candidates should fulfill the promises they make during campaigns?
People make a lot of promises, and
you think they should fulfill those promises. It was a brilliant campaign, remarkable campaign. And as a member of the cabinet of President Trump, do you feel an obligation to fulfill those campaign promises? I mean, when he asked you to come on, did you think you should fulfill the campaign promises?
I believe the Attorney General should enforce the law first.
I understand enforce the law, but he said you're helping him on the Muslim ban, on immigration issue. I mean, you think he should fulfill those promises?
President makes decisions, and if it's lawful, we defend it.
If it's lawful. Okay, I like that if it's lawful. But you said it was a remarkable and brilliant campaign. He said, quote, during the second debate, if I win, I'm going to instruct my Attorney General, that would be you, because he chose you, to get a special prosecutor to look into your situation, referring to Hillary Clinton, because there's never been so many lies, so much deception, end quote. And when Hillary Clinton responded, she said, because you'd be in jail. Are you going to fulfill that campaign promise he made during the second debate? Because he did say he'd put her in jail. He said he asked the Attorney General, you, to set a special prosecutor. That's what he said. It's a quote. I didn't make it up. What do you say? Are you going to keep that campaign promise?
I'll fulfill my responsibilities.
Are you going to keep the campaign promise? That's a yes or no. It's a promise that your boss, he hired you to fulfill. Are you going to fulfill?
We will comply with the law with regard to special prosecutor appointments.
Are you going to appoint one, as he promised during the campaign? He's reminded you a couple of times in a few of his tweets that that's what he wants you to do.
I'll fulfill my duty as Attorney General.
Okay. So the brilliant campaign, remarkable campaign, big smile on your face. You love the campaign, but you're not going to fulfill his campaign promises. I hope you don't in this particular case. So I'm kind of happy with your answer up to now. So, as Mr. Attorney General, I'm going to ask you another series of questions. And I'd like to go back to the beginning of the hearing and get you to answer the following question. Are you aware that you are under oath and that your answers must be the truth, the whole truth, and nothing but the truth, Mr. Attorney General?
I'm aware of that.
Okay, good. So I brought this little salt shaker here. And you'll forgive me if I just put a little bit of doubt into that answer. And just to remind myself that I might need this. And I ask unanimous consent that this article from Mother Jones Magazine be entered into the record with the headline, 3 times Jeff Sessions made false statements under oath to Congress. I ask this because I don't want to hear in a few days or in a few weeks that your answers, Mr. Attorney General, have changed based on newly uncovered evidence that what you told us before was in fact false, misleading, or something other than the truth, the whole truth, and nothing but the truth. I ask unanimous consent.
That objection be made a part of the record.
Thank you. Under oath, in the Senate, you said, as a surrogate, quote, a time or two for the Trump campaign, you did not have communication with Russians, but in March, it was revealed you did. Did you have campaign communications with the Russians? Because it appears you have had campaign communications with the Russians, Mr. Attorney General.
That is, I'd like to respond to that. I thought I had the paper right here. Surely I do. Here it is. Mr. Chairman, take a couple of minutes. I'd like to respond to that. Colleagues, I guess say former colleagues.
They left.
Senator Franken asked me this question. Okay, CNN has just published a story, and I'm telling you about a news story that's just been published. I'm not expecting you to know whether or not it's true, but CNN just published a story alleging that the intelligence community of the United States of America, the intelligence community provided documents to the president-elect last week that included information that, quote, Russian operatives claim to have compromising personal and financial information about Mr. Trump, close quote. These documents also allegedly say, quote, there was a continuing exchange of information during the campaign between Trump's surrogates and intermediaries for the Russian government, close quote. He goes on to say, now again, I'm telling you this is all coming out, so you know, but if it's true, it's obviously extremely serious, and if there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? I was taken aback by this. I'd never heard of this. This happened while I was testifying, I suppose. And I said, Senator Franken, I'm not aware of any of those activities. I have been called a surrogate a time or two in the campaign, and I did not have communications with the Russians, and I'm unable to comment on it.
And you're not going to correct that today?
My answer was responsive to his charge about a continuing...
Do you want to correct it or clarify it today for us?
The time of the gentleman has expired. The Attorney General can answer the question, but then we're moving on.
So this is really important. I appreciate the opportunity to share it. So my focus was on responding to the concern that I, as a surrogate, was participating in a continuing series of meetings with intermediaries for the Russian government. And I certainly didn't mean I'd never met a Russian in the history of my life. So I didn't think it was responsive, and my response was, according to the way I heard the question, as honestly I could give it at the time. I hope you'll treat me fairly when you evaluate that.
The chair recognizes the gentleman from Pennsylvania, Mr. Marino, for 5 minutes.
Thank you, Chairman. Thank you, General, for being here. I appreciate it. I'm going to ask you some questions because I am the chairman of the Regulatory Reform and Antitrust Subcommittee on Judiciary. And antitrust is an issue that is now surfacing more so than it ever has in the past. And the Justice Department's role is very critical in antitrust issues to determine whether there is an antitrust violation. I understand that the Justice Department's position on the AT&T merger will require divestment of some assets. Behavioral conditions have been used in vertical mergers since they pose a lesser danger to competition than horizontal mergers. Is the structural condition in vertical mergers a policy for DOJ at this point?
Antitrust policy is important. I've never been an expert at it. It was one subcommittee of the judiciary I never chose to be a part of. But we have an experienced team in the Department of Justice. We do try to handle each case professionally. We have a good chief now of the Antitrust Division, and I'm not able to announce any new policies at this time, Congressman.
Will there be a discussion concerning vertical and horizontal mergers when it comes to the so-called term behavioral conditions, where two companies that are merging may have to divest? Could there be future discussion as to when this behavioral condition would be implemented?
Well, the vertical horizontal issue is something that has always been part of the discussion. I don't think it's dispositive of any final decision, but I'm really not able at this time to comment on anything that would be part of an ongoing matter.
I understand.
And I appreciate you giving me an opportunity to not attempt to answer that.
I'm going to switch to human trafficking now. When I was a U.S. attorney, we handled some very heartbreaking and very severe situations concerning human trafficking. And I know that you understand, like I understand, the challenges involved there. But what can you tell me what DOJ has done in upping the prosecutions and the investigations for anti-trafficking?
We believe strongly that we can do even more. It's been a priority for a number of years. I was recently in the Minnesota United States Attorney's Office. They had a major international case, and I was surprised how much money was involved, almost as much as drug dealers may make. We have a recent report of our people meeting with the child exploitation group. My Associate Attorney General, number 3, Rachel Brand, is very interested in this, and I've empowered her to be engaged in advancing our efforts in this regard, and she's enthusiastically responding to that.
If I may make a suggestion as well, several years ago, we in the Middle District of Pennsylvania prosecuted one of the biggest sex trafficking cases on the East Coast, obviously for the most part, involving women and very young girls. We had a good conviction. These people went away for 30 or 40 years. But one of the areas that we have to help more with the victims is the protection side of things. Of course, during the investigation and during the trial, but subsequent to the convictions, that these women and children aren't forgotten, and there are protections there to keep them from anybody else attempting to do what's been done in the past. And I thank you so very much for your service to us, and I yield back.
Thank you for your service.
The chair recognizes the gentlewoman from California, Ms. Bass, for 5 minutes.
Thank you, Mr. Chair. Between 1956 and 1971, the FBI ran a counterintelligence program named COINTELPRO that was initiated by J. Edgar Hoover. COINTELPRO mainly targeted civil rights leaders such as Martin Luther King, and it's commonly understood that this was an abuse of its surveillance power in a manner to suppress a peaceful movement. So I would like to ask Mr. Chair unanimous consent to enter this report into the record, which is Black identity extremists likely motivated to target law enforcement officers. I believe earlier you said you were not familiar with the report. Is that correct?
Well, I haven't read it. I know some of the alleged targeting of officers by
okay, so I would
group.
like to know, and I'll ask you about that in a minute. So you are somewhat familiar with it. Who had the power in your department to order a report like this?
I'm not sure how that report got ordered. I don't believe I explicitly approved it or directed it.
Okay, so you haven't necessarily read the report, but you are familiar with the term black identity extremists?
Well, I think so, yes.
So can you tell me what that term means to you? Do you believe that there is a movement of African Americans that identify themselves as black identity extremists, and what does that movement do?
Well, it'd be interesting to see the conclusions of that report, but I'm aware that there are groups that do have an extraordinary commitment to their racial identity, and some have transformed themselves even into violent activists.
Are you aware of white organizations that do this as well? Given that white supremacy is well-documented, well-researched movements such as the neo-Nazis, the Ku Klux Klan, etc., are they white identity extremists?
I didn't follow that question. Please, again.
Is there a term or a report on white identity extremists? You mentioned you were familiar with black people who identify with their racial identity.
Yes, but it's not coming to me at this moment.
Not coming to you?
It's
certainly a group such as the Ku Klux Klan.
Yes, and then the skinhead movements, but there's a racial identity white movements that have been identified for sure.
So has the FBI done a report on white identity extremists that are likely motivated to target law enforcement officers? Is there such
I'm not
a
aware of that.
Okay. Are you aware of a group called the Sovereign Citizens?
I've heard that group, yes.
And I believe that the Sovereign Citizens is primarily a white organization that absolutely has targeted police officers and killed police officers. You're not aware of that?
I'm not aware of all their crimes, but I know they're a group that's known to have violent tendencies.
Could you name an African-American organization that have committed violent acts against police officers? Could you name one today? In this report, they name organizations from 30, 40 years ago, but can you name of one today that has targeted police officers in a violent manner?
I believe I could, but I would want to be to confirm that and submit it to you in writing. But I believe we had, within the last year or so, 4 police officers killed by a group that some have described as extremists.
So what has happened is that there have been a couple of incidents in which African Americans did kill police officers who were not associated with a black organization. And so one, for example, in Baton Rouge was associated with Sovereign Citizens, which is primarily a white group. So you should know that there's a lot of concern in the community, especially from organizations such as Black Lives Matter. By the way, would you consider Black Lives Matter a black identity extremist group?
I'm not able to comment on that. I have not so declared it.
So you should know that a lot of activists around the country are very concerned that we're getting ready to repeat a very sad chapter of our history, where people who are rightfully protesting what they consider to be an injustice in their community, which is their relationship with police officers, are now being targeted and labeled as extremists and are going through periods of surveillance and harassment. And so I would like to know, what is your department going to do to protect the rights of average citizens to protest if they have a concern about police officers?
This department will not unlawfully target people.
So if that's the case, then I would ask that you review this report, Black Identity Extremists Likely Motivated to Target Law Enforcement Officers, because I personally don't believe that any such organizations exist. The organizations that are referred to in this report are organizations from decades ago. And so I would like to know, what will you do to essentially roll back what is listed in this report? Because it's not accurate. Sir?
We will look at the report. I actually would be interested in reading it. But they usually do an excellent job, objective and fair, on those kind of reports.
Okay, well,
Time of the gentlewoman has expired. The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General. I want to cover a couple of areas, but I want to start with something that's very important to me. I think it's important to all people in this country of good conscience, irrespective of their political ideation, and that is the independence of the Department of Justice. And in my judgment, 2016 and 2017 have been challenging years for the Department of Justice. The decision to charge someone carries with it multiple layers of review. There's a grand jury, there's a petit jury, there's a trial judge, there are post-trial motions, there's appellate courts, there are courts of habeas corpus, and then there's the media, and then there's Congress. But the decision not to charge someone does not carry with it the same corresponding layers of review. But in some instances, it's every bit as important to understand why law enforcement did not do something and why prosecutors did not do something. I'm not interested in relitigating the FBI's decision not to charge Secretary Clinton. That decision's been made, it's been explained, and I'm not interested in relitigating it. I am, however, interested in reviewing 2016 and 2017 with respect to the Department of Justice. And Mr. Attorney General, there was a time when my colleagues on the other side of the aisle were interested in having some of these questions answered as well. It wasn't a year ago that some of my Democrat friends wanted Jim Comey investigated and prosecuted for a Hatch Act violation. That was 12 months ago. And it was absurd then, and it's absurd now. But what's not absurd is when my Democrat colleagues ask, why did you decide to publicize one investigation but not another? Why did you decide to appropriate a decision away from the Justice Department, which is very unusual for the head of the FBI to serve as both the investigator and the decision maker? Just like Republicans wanted to know, Mr. Comey, did you reach your conclusions before the end of the investigation? Did you make decisions whether to charge or not to charge before you interviewed all of the witnesses? These are questions that, to me, go to the core of whether or not the department can be respected, separate and aside from politics. I mean, I guess that certain departments are just inherently political, but the Department of Justice should not be. And so I tell you that up front, that Chairman Goodlatte and I are going to be looking into the decisions made in 2016 and 2017. And I think I can speak for him, and I know I can speak for myself. My motivation is a love for that department and a love for the concept of blind justice that doesn't care whether it's an even-numbered year or an odd-numbered year. And to the extent that there were decisions made, including the decision to write a public letter in October of last year and follow that up with another public letter in November. Those are legitimate questions, and I hope that the department will cooperate both with respect to making witnesses available, but also with respect to documents so Congress can better understand the decisions that were made and not made and restore some modicum of trust. That all people, whether they agreed with the decisions or not, at least understand why they were made. Now, Mr. Conyers asked you whether or not it was appropriate for the president to wait.
Could I respond just briefly to that?
Yes, sir.
You're familiar with the Inspector General,
I'm meeting with him,
and they make public their investigations. And several of the matters that involve the FBI are in the full and intense review by the Inspector General, and perhaps they can, under their rules of disclosure, perhaps you can inquire more about how that's ongoing. But I'm not able to give the details to you at this time. That's a serious matter. It's in my response to the chairman of yesterday.
Well, I didn't intend to ask you to respond to it because you're right. Mr. Horowitz is looking into it. In fact, I'm meeting with Mr. Horowitz this afternoon, not in that capacity, but in another. And you're right. At some point, he's going to let Congress know what he found, but that does not absolve us of our responsibility to also look into it. Mr. Conyers asked you whether or not it was appropriate for the president to weigh in an ongoing investigation. And, of course, the answer to that is no. It is not appropriate. It's not appropriate in 2017. It wasn't appropriate when President Obama did it in the IRS targeting scandal. It wasn't appropriate when President Obama did it in the ongoing investigation into Hillary Clinton's server. It is never appropriate for a president to tell a Department of Justice what outcome it should reach. I just wish my friends on the other side had the same outrage when President Obama did it as they do now. I mean, I guess that's what this will be my last question to you. You're nominated by a president. You're approved by a Senate, but yet you work for a virtue. You work for a blindfolded woman holding a set of scales, and that is what makes our culture different. How do you restore people's trust, Republicans and Democrats, confidence in a Department of Justice when it seems like different rules apply depending on who's in power?
The time of the gentleman has expired. The Attorney General will be permitted to answer.
Well, it's a good question and an important question. We intend to do our work according to the established principles of the Department of Justice. We will not be infected by politics or bias. We will make only decisions we believe are right and just, and we're not going to use the department to unlawfully advance a political agenda. We're going to enforce the laws of this country effectively as Congress has passed them, and I am determined that when the years go by, that people will say this Department of Justice did not crumble. It stayed firm and true to the great principles that I was taught in the 15 years I served in the Department of Justice, 2.5 as an assistant, 12 as United States Attorney, and looking up to the Attorney General is somehow so far removed from me that was beyond recognition. But now I'm in that position. I think I understand the gravity of it. I think I understand the importance of responding to your question, and we'll do our best.
Thank you.
The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. General, I have the honor of serving as chair of the Congressional Black Caucus. You were not there, but I'm sure you are aware, and if you're not aware, I'm telling on myself, that I testified against your nomination. And I did so because I was afraid that we would go back to a time where discrimination was rampant and that diversity was not appreciated and that the right to vote for minorities and African Americans would be further, more obstacles would be set up. And I listened to your opening statement and I listened to your remarks since then, and you talked about voter ID. The VC case, which in Texas ruled that their Texas voter identification law had discriminatory portions against African Americans. The district court ruled that way. The appellate court affirmed that ruling, and then you withdrew from the case after 2 courts ruled that it was discriminatory. How does that mesh, and then argued on the side of Texas, how does that mesh with the right to make sure that African Americans had unfettered access to the voting polls?
Congressman, the way that happened was that Texas had passed a voter ID law that the courts did not approve but struck down. Election was coming up, I believe, and the court approved a voter ID procedure that they approved for that election. And the Texas legislature then repealed its previous law that had been found to be unconstitutional or improper and passed the one that the court had approved. So we felt that the voter ID law has been approved. A proper voter ID law is constitutional, and we believe that one is constitutional, and that's why the position was changed.
And also in judging Department of Justice, in terms of nominating judges to the bench, our information tells us that out of all the judges that have been nominated, I think 91% have been white males. Does that foster diversity?
I'm not aware of the numbers, but you should look for quality candidates, and I think diversity is a matter that has significance.
Well, the National Bar Association could recommend and has recommended a number of African American and other minority attorneys who are qualified. So let me just ask you, and if you don't know the answer to these, just let me know that you'll get me the information. But how many African Americans do you have on your senior staff?
I do not have a senior staff member at this time. that's an African American.
Out of all
I would note in Alabama, I participated in recommending an African American judge, and I've had we're judges before, and
we're talking about this administration, though. Of all of the U.S. attorneys that have been nominated or confirmed, how many have been African American?
One in Alabama that I've recommended that I knew.
And I believe he's
been confirmed.
I believe it's only that one. Out of all of the special agents in charge of FBI bureaus around the country, how many are African American?
I do not know.
Would you get that for me? And here's the gist of what I'm saying. For a lot of people who objectively look from the back, like I do and many people where I live, the question is whether we're going towards inclusion and diversity or whether we're going back. So I applaud the president for his approach to the opioid epidemic, which everyone in this room is concerned about. We're losing over 100 people a day. But your decision to reverse Eric Holder's Smart on Crime initiative goes back to the crack, tough on crime, and I think you specifically said that you want the U.S. attorneys to charge and pursue the most serious, readily provable offenses and sentences. But with opioids, we're treating it as a mental health crisis. And the question becomes from the outside looking in, is it because of who the opioid crisis is affecting as opposed to crack? Our answer to crack cocaine was mandatory minimum sentences. So the question is, how does an outside observer reconcile how we treated crack, and which led to mass incarceration, which now with the epidemic we're losing thousands and thousands of people a year, and we're treating it with hugs and kisses and treatment as opposed to tough on crime, lock them up. How do I reconcile that and not conclude that the only difference is race and income?
Well, I would say that the federal court focuses on serious offenders, not users. We talk about international drug cartels. We talk about distribution networks, serious gangs, MS-13. We focus aggressively on that. But the PSN, new reinvigorated crime problem, focuses more, and I've been convinced of this, on the leading criminals in a neighborhood. And the federal government will not seek mass incarceration so much as we will be focusing on identifying the people who really are the driving force, maybe sucking other young people into crime that would never have been brought in there if they hadn't had this leadership drive. It's worked in New York, it's worked in other agencies, and I think it will work here. And Congressman, I would note that the average federal sentence in the last 3 or 4 years has dropped 19%, and the federal prison population is down 14%, while we are beginning to see a spike in homicides, the likes of which we hadn't seen since the 1960s.
Time of the gentleman has expired. The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, thank you for being here. Before I got to Congress, I was a computer consultant, so I'm a little, I sometimes dive into the nerdier end of things. The incursion into the DNC servers is back in the news recently. My question is, can you tell us if anyone at the DOJ, FBI, or any other federal law enforcement agency has been able to take a look and forensically examine that server to determine who hacked it, whether it was the Russians, an inside job, or somebody else?
You said the
DNC.
DNC. I'm not able to comment on that. It's ongoing investigation. And
I appreciate that. We've also talked a little bit today about the FISA court and 702 and surveillance. And one of the things that I don't think has been completely answered is why does the DOJ think it's so problematic to require a warrant from the FISA court before or any court before accessing or disseminating the contents of communications that aren't related to foreign intelligence that deal with American citizens?
Well, the way, maybe I should explain this. When you have a warrant or you have a surveillance on a foreign individual that may be connected to terrorism or any foreign individual, you listen to who they talk to. And if they call an American and you have a terrorist on the phone in Syria, you want to know who that American is.
But the USA Liberty Act includes exceptions for emergencies and for individuals who are reasonably believed to be engaged in international terrorism or furthering their goals.
Well, I'm not sure I understand it.
There's an exception for dealing with emergencies and people believed to be terrorists. It's the whole.
All right. Well, let me just say this. So if we get a lawful intercept from a federal judge of a mafia person in New York, he's not likely to be talking to many people not in the United States. And we're listening to the conversations of the people he talks to, and they're American citizens. And if they talk about a crime, you can use that evidence against them, and you don't have to have a separate warrant to access it. We're talking about in the 702 I hope you'll think with me now. So you lawfully obtain this information. You could do it by hand in the old days, but now the computers do much of the work for us. So you know the names of the people that may be involved in this activity, and you can access those records just like you could access bank records that you got.
If it came up in any other way, you would have had to have gotten a warrant to get that warrant.
Well, the problem with the warrant is, let's say this. Let's say you have information from an airport that somebody wants to learn to fly a plane but does not want to learn how to land the plane, as we saw one time.
And you go to the court and get a warrant in a matter of hours.
That does not give a probable cause to tap that person's phone.
I've got a couple other questions.
Okay,
I appreciate your answer on that. I do want to talk. In the last Congress, we passed and enacted into law the Stop Advertising Victims of Exploitation Act, or the SAVE Act. This legislation makes it a criminal offense to advertise for commercial sex acts. Has the DOJ used this provision to prosecute online sex traffickers or websites they use, and if not, why not?
I'm not sure about that, Congressman. I have to maybe can get back to you on that.
I would appreciate that.
Thank you.
All right, I've got a couple more here. I want to hit it, but I'm going to kind of take a step back and look at the big picture. I'm a lawyer. I went to law school. I've always considered the Attorney General to be the people's attorney. And I feel like over the past few years, under previous attorney generals, that the Attorney General has been more the president's attorney rather than the people's attorney. Can you tell me what you are doing in office to restore the confidence in the American people, both in the office of the Attorney General and agencies like the FBI, which most people used to have a very high respect for, but I believe that level of respect and trust has dropped dramatically in recent times?
These are serious questions. I believe as you get to know the FBI Director, Chris Wray, the new director, you will find him to be a man of high intelligence, great integrity, great character, and great capability. Clearly one of the nation's great lawyers in private practice, but many years in the Department of Justice as a prosecutor working with FBI agents. That's one thing we've got. I can tell you I have great confidence in him. My deputy, 27 years of professional that I chose to be my primary deputy. My associate attorney general, likewise, is a woman of the highest character and academic excellence and experience in the department. We are setting a tone of professionalism every day in what we do. So I think that's something we need to do. There are some matters that do need to be completed. The Inspector General is doing investigations of some significance, as in my letter. I believe you received a copy involving the FBI and the allegations that are there. We intend to make sure that no agency of the government, not just the FBI, is not following the kind of disciplines and practices they should follow. So I guess I would say to you, watch what we do. We're not going to be driven by politics. We're going to try to do the right thing, and I believe that time will show that to be true.
I see my time has expired. Thank you, Mr. Chairman.
The chair recognizes the gentleman from New York, Mr. Jeffries, for 5 minutes.
Mr. Sessions, I have a copy of the transcript of your testimony before the Senate Judiciary Committee in October. You stated under oath, "I don't recall," in some form or fashion 29 times. Is that correct?
I have no idea.
I have a copy of the transcript of your testimony before the Senate Intelligence Committee in June. You stated under oath, "I don't recall," in some form or fashion approximately 36 times. Is that correct?
I don't know.
In your testimony today, you have stated, "I don't recall," at least 20 times. Is that fair to say?
I have no idea.
Now, on October 4th, 2016, during a TV interview with Lou Dobbs, you criticized Hillary Clinton for telling FBI investigators, "I can't remember," approximately 35 times. You also stated during that Lou Dobbs interview that the intentional failure to remember can constitute perjury. Mr. Attorney General, do you still believe that the intentional failure to remember can constitute a criminal act?
If it's an act to deceive, yes.
Okay. Now, you testified in January that you had no contact with Russian operatives during the Trump campaign. Earlier today, you testified that your story has, quote, "never changed." Is that correct? That was your testimony earlier today, that your story has never changed, correct?
I believe that's fair to say.
Okay.
We've added things that I did not recall at the time.
Right.
So my statement at the time was my best recollection of the circumstances, and as things are brought up.
Claiming my time, I understand.
All right.
Sir, you now acknowledge meeting with Ambassador Kislyak during the Republican National Convention, correct?
I remember I made a speech. He came up to me afterwards. I was standing in front of the speaker program and did chat with him.
Okay, thank you. And you
encounter, not a meeting. It was just an encounter at that time.
Okay, and you also met with the ambassador in September of 2016 in your office, as you've acknowledged, correct?
He asked for an appointment. I had two senior staffers, both full colonels in the United States Army, retired.
Now, you testified, you testified in June before the Senate Intelligence Committee that you had not heard even a whisper about possible Russian involvement in the Trump campaign. Yet we understand that you attended this March 31st meeting where George Papadopoulos talked about potential communications with Russian operatives. But also, according to your third quarter 2016 FEC filing, you hosted a Trump campaign dinner meeting on June 30th, 2016 at the Capitol Hill Club. Is that right?
That's correct.
And your Senate re-election campaign paid for that meeting. Is that right?
I think that may be so.
Okay. And Carter Page and George Papadopoulos both attended that June 30th meeting, correct?
That has been reported.
And at that meeting, Carter Page told you that he was going to Moscow in a few days. Is that right?
Yes.
Okay.
And
thank you.
He said it was a brief meeting as he was walking out the door. I don't recall that conversation, but I'm not able to dispute it.
Understood. Reclaiming my time, I've got limited time available.
That is not. Does that establish some sort of improper contact?
I think you understand.
Russians?
I think you understand.
He's
that.
not Russian either. You know?
Understand, sir? I get to ask the questions. You provide the answers in this capacity. You're no longer in the United States Senate. You voted in 1999 to remove Bill Clinton from office on charges of perjury, correct?
That is correct.
In connection,
well, there were other charges. I voted
simple
for
question.
impeachment. Yes.
Yes, understand. To remove him, actually, impeachment's in the House. In connection with that vote to remove President Clinton from office, you gave this speech on the Senate floor on February 29th, 1999, and in it, you acknowledged that while serving as U.S. attorney, you once prosecuted a young police officer who lied in a deposition. And in that speech, you decided to prosecute that young police officer even though he corrected his testimony. Now, you testified under oath before the Senate Judiciary Committee in January. You subsequently corrected that testimony in a March 6 written submission and have been forced repeatedly to come back to the Senate and now the House to clarify. When explaining your vote on the Senate floor to remove Bill Clinton from office, you stated that you refuse to hold a president accountable to a different standard than the young police officer who you prosecuted. Let me be clear. The Attorney General of the United States of America should not be held to a different standard than the young police officer whose life you ruined by prosecuting him for perjury. I yield back.
The gentleman may
Are accused of perjury for answering the question the way I did in this hearing. I've always tried to answer the questions fairly and accurately. But to ask, did you ever do something, do you ever meet with Russians and deal with the campaign? You're saying Mr. Carter Page, who left that meeting, according to the press reports, and I guess his deposition or interview has been reported as saying, I'm going to Russia. I made no response to him, didn't acknowledge it. And you're accusing me of lying about that? I say that's not fair, Mr. Jeffries. I would say that's not fair, colleagues. That's not on any indication that I in any way participated in anything wrong. And the same with Mr. Papadopoulos. He talked about, it's reported in the paper, that he said something about going to Russia and dealing with the Russians. And I pushed back and said you shouldn't do it. So I don't think it's right to accuse me of doing something wrong. I had no participation in any wrongdoing with regard to influencing this campaign improperly.
The chair recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Well, thank you, Mr. Attorney General. You didn't do anything wrong in that testimony. This question was jarbled. That's just not giving you any benefit of the doubt at all to do what these guys are doing to you. So I hear what you're saying, and you didn't do anything wrong there. I do want to talk to you about your recusal from the Russian case. You cited 28 CFR 445.2 saying you were involved with the campaign. That triggered recusal. However, that regulation only applies to criminal prosecutions or investigations. When you recused yourself under James Comey's admission, that was a counterintelligence investigation, not a criminal investigation. So why did you cite that regulation to recuse from a counterintelligence investigation when its only applicability is for a criminal investigation?
I'm not sure that was expressed to me when I was given advice about it in those terms, number one. Number two, it could likely be interpreted as both. And so I felt...
Comey, after you recused, he testified March 20th. He said, I'm authorized to say there's a counterintelligence investigation. He was telling the president, you're not under investigation. So that's what he said. So I think that may have been misapplied, but I understand what you're saying.
I did follow the advice I was given.
I know you did. You've talked about you can't confirm or deny investigations. I think that's a good policy. Why was Comey allowed to confirm that investigation in March 20th, which invited all kinds of irresponsible speculation? You were recused. Somebody in the department authorized him to do that. Why did they break with the policy?
This was this March 20th you're talking about? I'm not, I don't recall how that exactly occurred, but I do agree with you, Congressman, that Mr. Comey talked more than he should. And he had no power, right, or justification in announcing the conclusion of a criminal investigation. He was the investigator, not the
I agree. I don't want to, sorry to interrupt. I got limited time. I agree with you. Let me move on. Uranium One case, I know you've been asked about it. Can you say, forget about whether it's under investigation, in the past, did the FBI or DOJ inform either President Obama, Secretary Clinton, or any cabinet secretary that it had uncovered evidence that Rosatom's main U.S. executive, Vadim Mikirin, was engaged in bribery, kickbacks, and money laundering before the Obama administration approved the Uranium One sale in 2010?
Is that the Mickerin matter, the matter that was prosecuted in Maryland?
2014, but there was an informant in 2009, 2010. The FBI had evidence of bribery, kickbacks, and money laundering. Was that information conveyed to any of the relative people on the CFIUS board? Clinton, other cabinet secretaries, or was it given to the president?
The way I understand that matter is that the case in which Mr. Mickerin was convicted was not connected to the CFIUS problem that occurred 2 to 3 years before. When the case came to the United States Attorney's Office, Mr. Rosenstein's office in Maryland, CFIUS had already been approved by 2 years or more.
There was an FBI informant starting in 2009.
Well, I have not talked with him, but the Department of Justice, I understand, has approved him providing information to the Congress, and I understand it'll be set up in a few days, and you'll be able to hear from him direct.
I think you should too, because from everything I've been proffered, he has evidence of illegal conduct 2009 and 2010 before this deal was agreed to involving Uranium One. It was all connected, and so I think that that's something that we need to do. And let me move on. The leaking you mentioned, you can't confirm or deny the existence of the leaks. Michael Flynn, some of these other leaks used politically against the administration. So let me ask you this: since the president was elected, has anybody been held accountable criminally or administratively for leaking information against the administration with a political motive?
Well, I think the individual in Georgia had a motive that's been charged, we have 27 ongoing investigations. Some of those involve leaks before President Trump took office and some after.
Final question. Just yes or no?
Before that, there was only 3 per year, only 9. There's 3 times as many this year as in the entire 3 years before being investigated.
Final question. Why can't you just tell us whether or not the FBI expended resources to give money to Christopher Steele? It's not about going into the investigation. We have oversight over your department. Were taxpayer dollars used to give to Christopher Steele, yes or no?
I'm not able to do that. I think for several reasons. It's an ongoing matter, and also it may well involve classified information.
Thank you, Mr. Attorney General.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. And I apologize in advance, Mr. Attorney General. I'm going to try to go through some questions quickly. Multiple trustworthy reports revealed last week that the Justice Department may require AT&T to sell CNN, among other assets, as a requirement for the approval of its proposed acquisition of Time Warner. Subsequently, more reports have surfaced that Rupert Murdoch, the chairman of 21st Century Fox and a confidant of President Trump, has twice contacted AT&T in an effort to buy CNN. This is, of course, very disturbing to those of us that are responsible for oversight of these issues. And my first question is, has any White House employee or official, including the president, contacted the Justice Department regarding the AT&T Time Warner transaction or any other transaction?
I'm not able to comment on conversations or communications the Department of Justice top people have with top people at the White House.
Well, Mr. Chairman, I'd ask that the witness be directed to answer the question. Either you're invoking the Fifth Amendment or you're invoking executive privilege. You just can't decline to answer because it's uncomfortable. So I'd ask, Mr. Chairman, that the witness be directed to answer my question.
The witness can answer the question in the fashion that he has determined.
Well, reserving my right, Mr. Chairman, then I'll move on. Mr. Sessions, are you not going to answer the question? Whether any White House officials have attempted to interfere or speak to the Justice Department about this transaction?
According to long-standing Department of Justice policy, the Department of Justice does not reveal privileged conversations or conversations between the White House.
I'm going to move on to a new area. The Foreign Agents Registration Act, you're familiar with it?
Right.
You think it's good policy?
I think it's a good law.
You enforce it, correct?
It has value, yes.
In addition to Paul Manafort and Michael Flynn, have any other Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registrations Act?
I'm not able to comment on that.
Why not?
Repeat the question. Perhaps I misunderstood it.
In addition to Paul Manafort and Michael Flynn, have any Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registration Act?
That would be a matter that should be directed to Mr. Mueller, I believe.
Moving to a new question. On October 6th, the Department of Justice, actually you, on the behalf of the Department of Justice, issued a 25-page memo to all federal agencies purporting to provide guidance on religious liberty protections under federal law. In the guidance, you indicate that an exemption or accommodation for religious organizations from anti-discrimination law might be required even where Congress has not expressly exempted religious organizations. You remember that, right?
Yes.
Okay. Would that mean, under your interpretation, that an employee of FEMA could refuse to provide disaster assistance to an unmarried couple who live together based on the employee's religious belief that men and women should not cohabitate before marriage?
I don't believe that it could be interpreted that way. It's just a policy document. We didn't try to write it.
I really like
well, you have to answer.
This is a yes or no. Would the guidance you provided permit a HUD-funded shelter to refuse to house an unmarried pregnant woman based on the grant recipient's belief that sex outside of marriage is a sin? Yes or no?
Every matter, first, I don't think so. Number one, under the guidance, but also the guidance does not repeal established laws that are in place, and it was written, that guidance was to clarify the established principles
Thank you,
of
Mr.
religious
Sessions. I have very limited
freedom.
time. I appreciate your answer.
Well,
now returning to the Papadopoulos issue. In your October 18th testimony, you purport to have forgotten this conversation by Mr. Papadopoulos about Russia that you put an end to. You said you weren't being dishonest, you weren't making a false statement, you simply forgot it. You remember that testimony?
Something like that,
okay.
Yes.
When did you remember the remarks of Mr. Papadopoulos? When did that memory come back to you?
I think it was when the press came up with it, or it was revealed in the press.
That was the first time you remembered it?
I would recall that my October statements was a broad question.
No, I understand. Mr. Sessions, I have a limited time reclaiming my time. Mr. Sessions, you were a senior campaign official and a member of the National Security Team. Did you ever exchange any email, text message, or any other communication to or from Mr. Papadopoulos about Russia or any other subject?
Repeat the category list of things?
Exchange any email, text message, or any communication to or from Mr. Papadopoulos about any subject?
I do not believe so. I'm confident. I did not.
Did anybody ever forward to you a communication from Mr. Papadopoulos?
I don't recall it.
Did anybody from the campaign ever communicate with you about Mr. Papadopoulos?
I can't say that there were no conversations about him before or after this event.
Were you told about
the push back at him?
The time of the gentleman has expired. The witness can answer the question.
Chair, I don't have a specific recollection, Mr. Chairman.
Mr. Chairman, I'd ask to make a unanimous consent request. I would ask unanimous consent to insert the following materials into the record. A letter from me and Ranking Member Conyers requesting a hearing on the President's interference with antitrust enforcement matters before the Justice Department. A letter from Senators Amy Klobuchar, Dianne Feinstein, and several others to the Justice Department urging it to oppose any attempt by the White House to interfere with antitrust laws, enforcement decisions, particularly for political reasons. A July article in the New York Times reporting that senior White House advisors have discussed using the AT&T Time Warner merger as a potential point of leverage over CNN, and 9 letters from as far back as February of this year from various members of the Judiciary Committee seeking information on a wide range of subjects addressed to the Attorney General of the United States that have been ignored, that we have received no response from.
Without objection, the document made part of the record. The chair recognizes the gentleman from Texas, Mr. Radcliffe, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, good to see you. If FBI Director Chris Wray held a press conference tomorrow without your knowledge to announce a charging decision in a major federal investigation, would you consider that an inappropriate departure from longstanding Department of Justice and FBI policies?
Under the situation today, under the letter that Deputy Attorney General Rosenstein wrote with regard to Mr. Comey, I think it would be a terminatable offense. It's not discipline. We need to be disciplined in this department. We don't need to be leaking, and we don't need to have people taking actions outside their realm. Maybe sometimes people make an honest mistake, but that would be a very dramatic thing, which he would never do.
I'll take that as an emphatic yes. Now, to your knowledge, are there currently federal prosecutors in your office that are predetermining cases prior to the interviewing of key witnesses to include the subjects or targets of those investigations?
I don't believe so.
Is it a practice in your Department of Justice to allow immunized witnesses to sit in the interviews of the subject or target of federal investigations?
That would not be a normal process for sure.
Mr. Attorney General, these are just a few of the irregularities or anomalies that have taken place in how the Department of Justice and the FBI have handled these investigations and prosecutions prior to 2016, and now apparently a departure from how you're handling them. It's also these irregularities that have shaken the faith and trust of people in our Department of Justice. Look, I'm of the opinion that for the last 8 years we have survived the worst presidency of my lifetime. My colleagues on the other side of the aisle have spent their time today trying to convince you that we have to survive a bad president right now. That's okay. For 240 years, our republic has withstood that. Elected officials come and go. But right now, where we are, and what our history won't tell us, is what happens to our republic if people lose all faith and trust in the Department of Justice and the FBI to fairly investigate and to prosecute violations of the rule of law. Now, at one point in time, you and I held the same position in the Department of Justice. I was U.S. Attorney, as were you. You've obviously been promoted. If public opinion polls tell us anything, the chair that I hold right now signals that I've been demoted. But my time as U.S. Attorney taught me something that you said in your opening, which is that the Department of Justice must always transcend politics to uphold the rule of law. I think more than anything else, what the American people want to hear from you today is that that is in fact the case. As Mr. Gowdy said in his line of questioning, Lady Justice is supposed to be holding a set of scales, wearing a blindfold. She's not supposed to have her finger on the scales. And I think that the American people have every reason to question whether or not that's where we are right now. So more than anything else, what I'm asking from you is to hear from you that you are prepared, that you are committed to go wherever the facts and evidence lead you, regardless of the political consequences for any political party or any person, to include Donald Trump or Hillary Clinton or yourself.
Yes, I am, and the Department of Justice is. You will soon have Director Wray, I believe, coming before your committee. I hope you'll ask him these questions, and I think you'll be impressed with his commitment in that regard. As United States attorneys, we were raised in that idea. I've never forgotten. I'm glad I had my 15 years in the Department of Justice before I came to Congress. You get your values shaped maybe at a younger age. But I think I understand the role I have, the responsibility we have to do justice. And I would say this, that in the long run, if I want the respect of this body, both sides of the aisle, I've got to follow the rules in the department. And it may frustrate you that I can't answer questions or confirm you or other members on this side. It may frustrate people on this side. But if I'm not prepared to do that, then I don't think I'll ever restore the Department of Justice. That's what our goal would be, to hopefully it's not as bad as you say, but I think there's danger out there, and we want to fix it.
Mr. Attorney General, thank you for your continued service. I yield back.
The chair would advise members of the committee that there are about 8.5 minutes remaining in this vote. The gentleman from California has persuaded me that will permit him to proceed but other members are advised we will reconvene immediately following this vote series. And the gentleman from California, Mr. Swalwell, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for appearing, Mr. Attorney General, and please express my gratitude to the men and women who serve the Department of Justice. You stated in your opening statement that my story has never changed, but Mr. Attorney General, it has changed 3 times, and today we heard the 3rd edition when you told us that you do now recall Mr. Papadopoulos mentioning that he had contacts in Russia. And so I have a slide for you that I'd like to display. It's a January 10th, 2017 exchange with Senator Franken where he asks about campaign communications with Russia. And you stated, Senator Franken, I'm not aware of any of these activities. Mr. Attorney General, if you were asked that question today, recalling that you are now aware of what Mr. Papadopoulos said on March 31st, would you answer that question differently?
All I would say to you, Congressman, is if you fairly treat the exchange I had with Senator Franken, I think you can understand where when I answered the question, I felt like I was answering it properly.
But you would agree today it should be answered differently if it was asked in the same form today, considering your recollection that you just gave us?
I believe that when you're asking me today, explicitly, did you meet with any other Russians? Today, I am prepared to say I did. I met with the ambassador in my office with at least 2 of my staff, senior respected patriots, colonels retired in the Army, and
Mr. Attorney
nothing
General,
improper occurred at all.
Once and for all, can we answer the question?
I am once and for all answering the question, Congressman. I don't understand why you won't take my answer.
Well, we're on the 3rd edition, Mr. Attorney General. So during your time on the campaign, did any person on earth state that they were communicating with Russians, traveling to Russia, or asked the campaign to meet with Russians, to your recollection?
Was I asked that question?
No, I'm asking you today, to your knowledge, did any person on the campaign tell you they were going to Russia?
I'm prepared to answer the question, but I just will not answer it in a way that suggests that I in any way intentionally misled anyone when I answered the question.
What's the answer to the question, Mr. Attorney General?
The answer is I met with the ambassador in my office for less than an hour, I believe, and he came up to me after a speech at the convention when it was raised to me that this months later. Nobody said immediately it was an error. By press, I immediately revealed and acknowledged or told them the meetings I'd had.
With respect to Carter Page, he told you, as you just acknowledged, that he was going to Russia. He was also on the national security team, and this is the 2nd person within about 3 months now that is bringing up Russian contacts, and you did not tell him to not go to Russia. Is that correct?
No, I didn't tell him not to go to Russia.
And you didn't tell anyone else on the campaign that he had told you that?
I don't recall him saying that, but am I supposed to stop him from taking a trip?
Well, at that point, did you think that now that 2 people have talked about either going to Russia or having contacts with Russia, that the campaign where you were the chairman of the national security team might have a Russia problem?
Well, if I read what's been said about the Papadopoulos meeting, the one that was somewhat earlier than that, I did say you don't represent something to I pushed back at his trip and was concerned that he not go off somewhere pretending to represent the Trump campaign. He had no authority for that. This young man didn't have any ability and ought not to be going off representing the campaign.
Mr. Attorney General,
the next one is Carter Page, and he says, from what I see in his testimony, interviews, he said after the meeting was over, he goes out and
moving on, Mr. Attorney General.
He goes out and he says he's going to Russia. I made no response.
CIA Director Pompeo has called.
So what does that mean?
Well, the American people will judge that. I don't think it means that
I've done anything dishonest.
Mr. Attorney General, the CIA Director has judged that WikiLeaks is a hostile, non-state intelligence service. Do you agree?
I'm not able to disagree with that.
But candidate Trump, who you were working for...
He's more aware of its activities, perhaps, than I.
But candidate Trump said throughout the campaign, I love WikiLeaks. Do you love WikiLeaks, Mr. Attorney General?
I'm not a fan of WikiLeaks.
Do you think it was appropriate that Donald Trump Jr. communicated with WikiLeaks during the course of the campaign?
I'm not able to make a judgment about that.
Thank you again for...
Time, gentlemen, has expired. The committee will stand in recess until immediately after this vote.